Hey there, I'm Louisiana estate planning attorney Paul Rabalais, and in this video, we're going to talk about the very first decision that often gets made as part of completing a succession when somebody passes away. All right, so successions confuse everybody. Nobody really understands the procedure and the steps and all that. So I'm going to break it down and really just focus on the very first decision that gets made when a family initiates a conversation with perhaps a succession attorney about completing the succession. So the first decision to be made is that decision whether to administer the succession or not. So it's to administer or not to administer. That is the question. Maybe the best way we can analyze that question is to look at an example. And we'll go through kind of the cycle of a married couple and how each spouse passed away at a different time. But let's keep it fairly simple. Let's say in our example, there's a husband and a wife, and the husband dies first, and he has a will leaving his estate to his wife. I leave all of my property to my wife. His will says something like that, leaves everything to his wife. And perhaps he named his wife as the executor of his succession. So husband left everything to wife. They have the typical assets, which is a house. They have an IRA, or he has an IRA. They have a brokerage account. They have maybe 2 or 3 bank accounts, probably a checking account, a savings account, maybe even a CD. They've got a couple of vehicles. They have no debts. Relatively simple. Now, when the husband dies, one of the decisions about whether to have an administration, and which means getting the wife confirmed as the executor by going through a court process. One of the factors that plays into whether we go through that step is, okay, everything's going to the wife. Is there an urgent need to get the wife access to the money while this succession is going on? So we look at that and we realize on all of the bank accounts, they're joint bank accounts, the bank is permitting the wife to continue to access and transact all of the bank accounts. The husband had an IRA. He named his wife as the primary beneficiary. So once she gets the death certificate, she submits that to the financial institution, and they move the husband's IRA into an IRA in the wife's name, so she has access to all of that. She doesn't have access to that brokerage account that's either in the husband's name, and she may not even, depending upon the brokerage firm, she may not even have access to it if it was in both of their names, or maybe the brokerage firm will give her access to her 1/2 community property interest. She's not looking to sell the house or the vehicles anytime soon. She's going to keep living in the home. She was advised by someone, don't do anything within a year, so she's going to hold on to the vehicles. So in this circumstance where the husband left everything to the wife, nothing was complicated, there was nothing frozen that the wife needed to access immediately. She didn't need to access the brokerage account. She didn't need to sell the house, sell the car immediately. So a decision was made to complete husband's succession without an administration. We could skip the step of wife getting confirmed as the executor, wife opening an estate account, and didn't need to do that. So husband's will named wife as executor, but we didn't actually take that step of getting the wife as confirmed. Really what we did is we prepared a bunch of court documents, including the required detailed descriptive list of assets and liabilities, and we prepared a petition that the wife signed. And that petition was something that the lawyer prepared, and it basically laid out the facts that the husband left everything to the wife in his will, that he had these assets, and it's a petition asking a judge to sign an order called a judgment of possession, ordering that all those assets be transferred into the wife's name. So we just one shot, petition for possession and judgment of possession. Judge signs judgment of possession. We get that order recorded in the real estate records of the parish where the house is located. That transfers the house from both of their names into just the wife's name. We get a certified copy of that judgment of possession to the Office of Motor Vehicles. They'll issue new titles solely in the wife's name. And we get a copy of that court order, judgment of possession, to the brokerage firm. They'll retitle that account solely in the wife's name. So that was one where we were able to do it without an administration without getting the executor confirmed, without the wife having to take any actions as an executor. Now, let's fast forward. Now, wife later passes away. Wife's will left everything to husband, but he died, and so wife's will also said, if my husband dies before me, I leave everything to my 3 children. And let's say the wife named the oldest child as the executor of her succession. And the wife died basically with the same assets that existed when the husband died. The house, the car, she had the IRA, the brokerage account. Now it's a little trickier because now we have an estate. Now some things need to be liquidated in order to divide things up 3 ways among the 3 children. Everyone feels it's best to sell the house relatively quickly, sell the vehicle or vehicles relatively quickly, divide up the brokerage account 3 ways among the 3 children. And now it's more appropriate to have an administration. So oldest child gets confirmed as the executor. So that's an extra layer of paperwork we do first thing. So we get the original will, we prepare the petition to get that oldest son confirmed as the executor. We file all of that at the courthouse. A judge signs an order ordering that the will is valid and that the son is confirmed as the executor. The clerk of court issues what's called letters of independent executorship, which son or oldest child takes to the bank and opens up an estate account. Now that executor can sell the house on behalf of wife's estate. Proceeds from that sale go into the estate account. Executor can sell vehicle or vehicles. Executor can sell brokerage account assets, liquidate all of that stuff, put it into an estate account. And then ultimately we go back for that last round of paperwork where we petition the judge to sign the judgment of possession, which orders that executor to transfer all estate assets to the 3 children equally. So in that situation, it was a little bit more complicated. Things needed to be liquidated. You needed to have an executor to be able to handle all those sales of estate assets. So we did do an administration when the surviving spouse died, which is common because things needed to be divided up among the 3 children. So that's that first decision when somebody passes away. When you're starting the succession, do you do that administration or not? Do you get that executor who's named in the will confirmed as the executor? There's never really any harm in doing an administration. It's just an extra step, but if you're not sure whether you should be doing an administration or not, it's probably best to do it because sometimes things pop up in the middle of a succession and you're like, darn, I wish we had an executor confirmed because this thing that just popped up, we need an executor, which is maybe deal with some third party on behalf of the estate, deposit some check that might be a refund from wife's assisted living facility that needs to be deposited into an estate account. And the only way to create an estate account at the bank is to have an executor confirmed, and because the bank's not going to allow the estate to open a bank account until they see the court orders where they know who to open that account in the name of on behalf of the estate. So if you're not sure, probably best, by default to go ahead and open that succession by getting that executor confirmed. But every situation is different. So just a quickie there on administer or not to administer. That is the question. Make sure you like, comment, subscribe. We'll see you next time.